Based on what we've done so far, you're probably asking yourself, what is it if it's not an offer? It looks like an offer, but it's not an offer, so what exactly is it? For instance, if we go back to the Gibson case, Gibson and the Manchester City Council, you'll recall Mr. Gibson got a letter from the council, and the council stated in its letter that it may be interested to sell all the council apartments, and in particular Mr. Gibson's apartment, to him, because he was a sitting tenant at the time. So in other words, essentially what the council was saying in its letter was, Mr. Gibson, would you be interested in buying the council flat? And he responded essentially by returning the form, and that is tantamount to saying, yes, I would be interested. But as we already discussed, that's not enough for there to be a contract. In particular, the letter sent out by the council was not an offer. Hence, it's not capable of being accepted because there was information missing. And so what exactly is it? And what it is that it is an invitation to treat. Now this term comes from the Latin, invitatio ad offerandum. Literally it means that you are inviting an offer. Would you be interested to buy the apartment, the flat? And you would then say yes. So in essence, you are being invited to make an offer. So perhaps Mr. Gibson would have said, well, yes, I'm interested in buying at such and such price, and so on. Now, in that case, Mr. Gibson would then become the offeror, the person making the offer. So the council would be the party making the invitation, inviting Mr. Gibson to make an offer, and then Mr. Gibson makes that offer. So that, in a nutshell, is this concept of invitation to treat. In the US, you often come across the term invitation to bargain. Sometimes you come across the term invitation to negotiate. These are all the same things. Now, what distinguishes an invitation to treat from an offer, very simply, is that an invitation to treat is not capable of being accepted in identical terms. What does that mean? What that means is, very simply, you are not able to say, I agree, and then you have a contract, because there's something missing. So at least one of the four elements that we talked about earlier is missing. There's not enough information there. So you're not able to say, I agree. So for instance, in Mr. Gibson's case, the council says, would you be willing to buy? And if he says, I agree, well, that's not really the right answer to that question, is it? Because there's elements that are missing. As we already talked about, the time frame, for instance, hasn't been made clear. If instead the council had said, would you like to buy at this price and at this time frame and so on and so forth, and he would have said yes, then perhaps it might have been an offer. But of course it wasn't. It was merely an invitation to Mr. Gibson to make an offer by submitting the application form. Now, we find invitations to treat in various different scenarios, and so we'll go through those one by one. Probably the most common scenario is advertisements. So you'll see an advertisement in the paper, and usually that would not be an offer. Instead, it would be an invitation to treat. Now, we already looked at the exception, or the ostensible exception, in Carlyle and the Carbolic Smoke Bowl Company. But now let's look at some more straightforward cases. So for instance, we have the case of Partridge and Crittenden, very famous case. This case involved an advertisement that offered for sale some wild birds. Now, it was against the law to sell such wild birds. And so the question came up as to whether this was really an offer. Because in order to fall foul of the law, which prevents you from selling wild birds, you must have engaged in making an offer which was capable of being accepted in identical terms. In other words, capable of someone coming forward and saying, yes, I will buy the wild bird, and the contract is complete. So in other words, it's no longer in the hands of the offeror. And so this is really what the case looked at. Someone who puts out that advertisement, wild birds for sale, have they made an offer? And would that offer lead to a complete contract as soon as someone steps forward and says, yes, I will buy those birds. And it turns out that the advertisement was not an offer. Because ultimately, what happens when you put out an advertisement is that people see it, people come forward, and then when someone comes forward and says, yes, I want to buy those birds, it is then up to the seller to say, well, yes, I agree, I will sell them to you, or I will not sell them to you. So in other words, the advertisement itself is an invitation to treat, inviting other people, the people who read the advertisement, to come forward and make an offer. And so in Partridge and Crittenden, there was no offer. In Granger and Son and Goff, the situation was very similar, only that the advertisement was not for wild birds, but it was a price list for wine. Now, a price list for wine, again, lay people may feel that that is an offer because you have particular wine listed and particular prices listed. But does that mean that someone who sees that price list and comes forward and says, I will have 10 bottles of that wine and sell them to me right now, would that then constitute a completed contract? And again, the answer is no. What it is an invitation to treat. So someone who wants to have those 10 bottles of wine would then come forward and say, I want to have those 10 bottles of wine. And then it is up to the wine merchant to say, yes, I will sell them to you, or no, I will not sell them to you. And this makes perfect sense. And I think the wine example is a very good one, because what if the wine merchant doesn't have 10 bottles? What if 100 people come forward and all of them want to buy wine and there just isn't that amount of wine going around? So obviously there can't be a contract in all these cases. So what it is instead is that the price list of the wine is an invitation to treat, which invites parties who see the price list to come forward and make an offer, and then it is the wine merchant who either agrees or doesn't agree. Aside from advertisements, shop displays are a very prominent example of invitations to treat. Now, the issue with shop displays is as follows. You go into the high street, you pass a shop, you see something in a display that you like, it's got a price tag, and you go into the shop and you say, I'll have it. Usually, of course, it's not a problem. But what if the shopkeeper says, no, I'm not going to sell it to you, or I'm not going to sell it to you at the price as it was displayed? So a lot of people will probably think that's unfair. Now, for the purposes of contract law, and we're not talking about other types of laws here for the moment, such as consumer protection laws and so on and so forth. So strictly from a contract perspective, from an offer perspective, in fact, shop displays are not offers. Shop displays are invitations to treat. So what that means is, just as what we talked about in respect of advertisements, people who are in the high street, who walk past the shop, who see the display, who might even see the price, they are invited to come forward, go in the shop, and make an offer. So when someone goes in the shop and says, I saw that display, I want to buy that shirt, that dress, whatever it is, they are in fact making the offer, and then the shopkeeper gets to decide whether they will accept the buyer's offer or whether they're not going to sell that item to the buyer. So this was established a long time ago, as you can see there in Timothy and Simpson in the early part of the 19th century. So this principle, this rule has been around for a long time. A very famous case that you've probably already come across, at least heard the name of, is Fisher and Belle. And it goes to show once again that shop displays are merely invitations to treat, they are not offers. In Fisher and Belle, there was a shop display, and the shop display had a flick knife displayed in it. However, selling such flick knives was illegal under statute. And so the question, a bit similar, I suppose, to what we discussed in respect of Partridge and Crittenden, was the shop display, the display of the flick knife, capable of being accepted in identical terms? So would someone who came to the shop, went inside, a buyer, and said, yes, I accept, would that then automatically form a contract between the seller of the flick knives and the buyer of the flick knives? And the court held no. So the mere display of the flick knives, even though the sale of the flick knives was illegal, the mere display thereof was not held to be illegal under the relevant statute, and that is not something that we should be concerned for the moment. What we're concerned with is the part why there was no breach of the statute, and the reason why was because displaying the flick knife did not amount to an offer. It was merely an invitation to treat. So ultimately, it was still up to the shopkeeper to say, no, I'm not going to sell it. And since the shopkeeper had retained the authority, the right to say no, there could not be an argument that the shopkeeper was in fact making an offer, and that anyone who would come forward and said, yes, I agree, I want to buy it, would then immediately, by saying those words, form a contract. So in the end, and this goes for Partridge and Crittenden as well, by the way, you can tweak the legislation a bit to cover invitations to treat, but at the time the legislation did not cover invitations to treat. So what we learn from this case, and as we learn also from the other cases, is that a mere shop display, putting something in your shop window, is not an offer. Now, the extension to that shop display is self-service shops, supermarkets. Now, we have a very famous case as well, and I'm sure you've heard of it already, which is the Pharmaceutical Society of Great Britain and the Boots chemists. Now, Boots, of course, is that's the drugstore that you've probably seen, which is, of course, still around. And the issue was, and you can see this is 1953, so this is a long time ago, and back then self-service shops were not the norm. Nowadays, of course, they're everywhere. The question was it an offer when something was displayed in the supermarket for people to self-service, to pick out, put in their basket, and then by doing so, they would have accepted and there was a contract for sale? And if that was the case, so if the display of something in a supermarket type scenario, in a self-service type shop, if the display was an offer, and by picking it out and putting it in the basket, you were accepting the offer, then that would have been a problem for Boots. Because one of the things they had on their shelves, of course, is drugs. Aspirin, any kind of drugs. And as you will probably know, a lot of drugs require for a registered pharmacist to be in the room, in the presence, while the of the buyer, while the transaction takes place. And in a self-service environment, that you could argue is not the case. So that really was what it was all about. And the court quite clearly came down on the side of saying a self-service shop, when things are displayed on the shelves, that is not in and of itself an offer. That, just like with shop displays, is merely an invitation to treat. And the buyer, the person who goes to the self-service shop, by picking it from the shelves, putting it in their shopping trolley or putting it into their shopping basket, taking it to the cashier, they're the one, when they go to the cashier, making the offer. In essence, the buyer is saying, will you sell these items to me? And then the cashier gets to have the final say, yes or no. So that, of course, then also resolves the problem of not having a registered pharmacist around, because the cashier might say, no, I'm not going to sell it to you because, for instance, the pharmacist isn't around. And you could then also apply the same logic to things like alcohol. So you go to a supermarket, you pick out a bottle of wine, but let's say you're underage. Now, by picking it out, have you accepted? And as we just discussed, no, you haven't. By picking it out or taking it to the cashier, what in effect you're doing is you are asking the cashier, will you sell this bottle of wine to me? And if you look underage, the cashier might say no. So no offer, no contract. In essence, the shop has not made an offer. It has only made an invitation to treat. You are the one making the offer, and then the cashier decides whether to accept your offer or not. So that's the precise, the correct technical way of looking at these scenarios. Now, interestingly, in the Boots case, there was an obiter. Now, you will recall obiters are a bit similar to ratios, but they don't quite amount to a ratio. And the big difference is that obiters are things that are said by the way, which do not which are not based on the facts of the case. So the ratio is the principle that we extract from a case, which is based on the facts of the present case. Obiters are principles that we can extract from cases which are not based on the facts of the case. Now, very interestingly, in the Boots case, in the judgment, you'll find a passage about a bookshop. Now, of course, the Boots case was not about a bookshop. It was about the Boots chemist. And the passage basically says that it would be exactly the same in a bookshop. So if you went to a bookshop and picked out a book and took it to the cashier and handed over the money, would that amount to acceptance? And having the book displayed in the bookshop would have been the offer in that case. And the judges argued, no, it's exactly the same in the bookshop case as it is in the drugstore case. A book being displayed in the bookshop is merely an invitation to treat. The person who picks out the book goes to the cashier. That is the person who makes the offer, and then the cashier is the person who either accepts or does not accept. So that's an interesting observation as part of the Boots judgment. And of course, as we found in subsequent cases and since 1953, that is in fact the law that applies to all types of self-service environments. So it doesn't necessarily have to be just drugs or just alcohol. It could really be anything. Anything that is in a self-service shop is not an offer just by the mere fact that it is displayed in a self-service shop. You go there, you pick out whatever you like, and you're the one as the buyer who makes the offer to the cashier, and then the cashier usually, of course, would accept your money, and at that point the contract would be complete.